everyone, welcome to our concepts पढ़ाएंगे सबको सिखाएंगे campaign video, and in this video we'll be discussing about one of the basic and important concepts under the Indian Contract Act, and that is consent and free consent. जैसा कि हम जानते हैं जब हम Contract Act पढ़ते हैं तो वो मेंशन करता है there are certain essential ingredients which make a contract valid one. So जब हम validity of contract पढ़ते हैं तो free consent is one of the important essential ingredients for that. So what is consent? We'll be first understanding that, and based on that we'll be understanding what does free consent means and is there any difference between these two concepts. Do remember to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. अगर आप कोई भी questions or queries हो आप हमें कॉल कर सकते हो इस नंबर पे या फिर आप हमें मेल भी कर सकते हो इस आईडी पे. You can also visit our website where you can get all the details with respect to the upcoming government exams. Now talking about the consent. So this term consent that has been actually defined under the Indian Contract Act, and to simply put it, consent basically means when two or more persons agree upon the same thing in the same sense. So जब दो लोग जो parties हैं contract में enter कर रहे हैं अगर वो agree करते हैं same thing पे in the same sense तो हम कहते हैं there is a consent being given by each of them in that particular contract. So इसको हम simply एक example से समझेंगे. So suppose if I want to sell my car to my friend and I have two different brands of car with me. मेरे पास Skoda का brand भी है और से मेरे पास BMW भी है. Now, since I want to sell my Skoda car, I make an offer to my friend and I tell him that friend, I want to sell my car to you at this particular price. Will you like to buy it? My friend wants to purchase the car, but he is thinking to purchase the BMW car. यहाँ पे मैंने उसे ऑफर दिया अपने Skoda कार को सेल करने के लिए. मेरे फ्रेंड ने ये सोचना है कि मैं उससे ऑफर दे रही हूँ BMW के लिए because I just made an offer to him that I want to sell my car to you, to which my friend agreed, okay, I'll purchase your car. So यहाँ पे क्या हम कह सकते हैं कि consent है parties की? No, there is no consent because they are not agreeing upon the same thing in the same sense. So यहाँ पे consent नहीं है because we are not agreeing upon the same thing in the same sense. Now, there is a Latin phrase which is consensus ad idem and which means meeting of the minds. So for a consent, there should be the meeting of the minds. So in this case, there is no meeting of the minds since both the parties are thinking on different lines. Both of them are not on the same track. So we cannot say that there is a meeting of minds of the parties in this particular situation. Now, based on this, we'll be now understanding what is free consent. अब consent को हम free consent कब कहेंगे? So Contract Act कहता है कि consent को हम free consent तभी कहेंगे जब वो influenced या affected नहीं है either of these things से. So when the consent which the parties give for a contract that is not affected or if it is not influenced by coercion, undue influence, fraud, misrepresentation and mistake, then we say that the consent which is given is a free consent. Okay, अब यहाँ पे जब मैंने अपने कार को सेल करने की बात की और मेरे फ्रेंड ने उसे परचेज करने के लिए अग्री किया, so there was consent in this situation? No, as we have already seen why. But if I was talking about selling my Skoda and my friend was also thinking of purchasing Skoda, so there was a consent. And was this consent a free one? Yes, because it was not affected or influenced by coercion. But if on the other hand मेरे फ्रेंड ने मुझसे कहा होता कि अगर तुम मुझे ये कार नहीं सेल करोगी then I will shoot you. So there is the presence of coercion over there, and so इसलिए हम कह सकते हैं कि मेरा जो consent था for selling of the car in this particular situation that was not a free consent क्योंकि मेरे फ्रेंड ने मुझे threat दिया है कि अगर मैं उसे कार नहीं सेल करूंगी तो वो मुझे शूट कर देगा. Now we will be looking on each of these aspects. Talking about coercion. So what is coercion? is simply हम समझ सकते हैं use of threat या force होता है that is basically used for obtaining the consent, and वहाँ पे जो है there is pressure being put by the party. So you can see that in these two ways there could be a pressure being put on a person to obtain his consent either by committing or threatening to commit any act which is forbidden by Indian Penal Code or unlawfully detaining or threatening to detain any property. Talking about undue influence. Undue influence is basically nothing but the presence of dominance, you can say. When there is a presence of of dominance in a situation, we say there is an undue influence, where dominance जो है that is basically used for what? For obtaining unfair advantage over the other. So जो dominant position में होता है वो obtain करता है unfair advantage जो है, and जो person dominate कर रहा है the very will of the other, he is actually having a real or apparent authority, like as the case of, we can say, police officer and the accused, then fiduciary relationship, that of a parent and a child, or advocate and a client, you can understand, and those persons who are mentally affected. So undue influence is nothing but the use of dominance for obtaining unfair advantage. So अगर कोई भी unfair advantage नहीं है, that means there is no undue influence in that particular circumstance or situation. Now talking about fraud. So fraud is the very intention to deceive someone or to induce someone to enter into a contract. So the intention in fraud is to deceive the other party. So for deceiving the other party, there could be concealment of the facts by one of those who is aware of it, जिसे उस particular fact के बारे में सच्चाई पता है, फिर भी वो conceal कर रहा है उस particular fact को, because वहाँ intention क्या है? दूसरे को धोखा देना है, deceive करना है, ताकि वो particular person जो है enter कर सके contract में. वहाँ पे एक promise होता है, but उस promise को perform करने का intention नहीं होता. मैंने promise तो कर दिया कि मैं ये करूंगी, but there is no intention over there of me that I'll be performing that particular promise. There are acts which are involved that will be leading to deception. Deceive करना ही intention है, so the acts will be involved which will be leading to deception, an act or omission which the law considers fraudulent. Now looking on to misrepresentation. So misrepresentation and fraud is having a very thin line of difference, but misrepresentation क्या हो गया? Misstatement of fact हो गया, which is material to the contract. यहाँ पे भी misstatement है facts का. False statement made by a person, यहाँ भी false statement है जो कि एक person दे रहा है, but who believes it to be true. ये difference आप समझ सकते हो. यहाँ fraud में क्या था? False statement दिया जा रहा है, conceal किया जा रहा है facts को, but intention क्या है? Deceive करने का ही. So deceive करने के intention से जब आप conceal कर रहे हो facts को, then there is a fraud. But misrepresentation तब होगा जहाँ false statement एक person दे रहा है, मैं एक false statement दे रही हूँ, but मैं खुद ये believe करती हूँ कि वो जो false statement मैं दे रही हूँ वो actually false नहीं है, वो true है. The particular false statement which I am making is actually true to the best of my knowledge, and so I am not considering that that is a false statement being made by me, and so there is no intention to deceive the other party. और मैं जब false statement दे रही हूँ जिसे मैं सच मान रही हूँ, मेरा कोई intention नहीं कि मैं सामने वाली पार्टी को deceive करने वाली हूँ, तो उसे हम misrepresentation कहेंगे. Consent obtained by misrepresentation, that is voidable or avoidable, you can understand, which can avoided by the party. Now talking about mistake. So mistake is basically incorrect idea or opinion about something. So when parties to a contract, they are having any incorrect idea or opinion about something, or when the parties do not agree upon the same thing in the same sense because of some misunderstanding, then we say that there is a presence of mistake. So mistake can be of mistake of fact and mistake of law. Mistake of fact can be unilateral, where one of the parties is at mistake, and in bilateral mistake, both the parties to a contract are at mistake. Unilateral mistake of fact is basically a valid one. Bilateral mistake of fact is basically a void one. When we talk about mistake of law, there is mistake as to Indian law and there is mistake as to foreign law. So as to Indian law, it is not considered to be a voidable one, and mistake of law as to foreign law, that is same as mistake of fact. Now mistake of law, that is not being excused. So ignorance of law excuses basically no one, and there is a maxim with respect to that, which is ignorantia juris non exequat. And with respect to mistake of fact, ignorance of fact is an excuse, and that is being termed as ignorantia facit excusat. So this was with respect to consent and free consent. Do remember to stay tuned to our channel so that you can prepare 50% faster with us.